before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can place your hand down. Thank you. Ms. Waldrop?
Yes, Judge. This is position number 2 on your calendar, State versus Courtney Jackson. Defense counsel and I came to a negotiated resolution in this case on the count of theft by shoplifting. We agreed to a sentence of 12 months, credit for time served, with the balance to be on probation. For Ms. Jackson to complete a theft class and stay away from Lenox Mall. We did agree that it could terminate upon successful completion of all conditions. Counsel, do you stipulate to a factual basis, venue, and identification for purposes of the plea?
We do so stipulate, Judge, and we also ask this court to accept the plea as negotiated. I do have one edit. Miss Courtney Jackson has provided me her driver's license. She actually spells her name with an N-E-I. So I just wanted the record to reflect correctly the last letter of her name.
It's an I and not a Y.
That's correct, Judge.
Yes, Judge, and we would just ask that they waive any defects in the accusation with regard to the spelling of the name.
Okay.
We do, Judge.
All right. Ms. Jackson, it's my understanding that in case 20 CR 005648, you wish to plead guilty to theft by shoplifting. Is that correct?
Yes, with a sentence of probation. Yes.
Okay, you step up to the mic a little bit for me.
Yes.
Okay. Are you under the influence of any drugs or alcohol this afternoon?
No.
You've been represented by counsel. Are you satisfied with her representation?
Yes.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No.
I'll accept the plea as negotiated. Ms. Jackson, let's see. As soon as you complete the theft class, the probation will terminate. We'll give you where you need to go to probation. Today, I ask that you report within the first 2 weeks or so, okay?
Okay.
All right, good luck
Thank
to
you.
you, ma'am.
Thank you, Judge. Does she just need to scan the QR code?
Yes.
I'm sorry, counsel, can y'all confirm, credit for time served?
I think it's just one day.
One
She
day,
was given a
okay.
citation.
Thank you.
Let me go ahead and call the bench trial calendar for this afternoon. Position number 1, Terensico Ayala.
Judge,
Yes.
Attorney David Rigdon here for that case and Mr. Ayala as well.
Okay, where are we with this matter?
What say the state?
Your Honor, I just need to get in touch with my officers, make sure that they get their ETA. Ms. Dennis, Deshauna Dennis, just need to make a phone call on that, Judge. And then also to Judge, this case was previously set on a bench trial calendar. At that time, we informed the court of the conflict that we believe existed with Mr. Fortis representing Ms. Dennis on a felony charge of aggravated assault. That charge involves the defendant, in this case, Mr. Ayala. And then his office through Mr. Rigdon representing Mr. Ayala on this case, the victim, which includes Ms. Dennis. And so at that time, you, Judge, ordered the defense to get a written waiver of conflict for professional, the Georgia Professional Rules of Conduct 1.7. That was to be in writing after the parties had an opportunity to consult with a lawyer and then be advised of the reasonable and adequate information about the material risk and alternatives to the representation. And then also after them having been given the opportunity to consult with independent counsel. If you'll recall, the fact that Mr. Fortis represented Ms. Dennis, and she was at the time, I believe, maybe incarcerated, it was preventing us from being able to speak with her. She was a defendant on a case, and we could not speak with her. Your Honor, I'm not sure after even reviewing the rules of professional conduct that the written conflict waiver would even, get rid of the conflict, because the professional rules of conduct specifically state that a client's informed consent is not permissible if the representation includes the assertion of a claim by one client against another client represented by the lawyer in the same or substantially related proceeding, or involves circumstances rendering it reasonably unlikely that the lawyer will be able to provide adequate representation to one or more of the affected clients. And so I don't even know that a written waiver in this case can waive the conflict that exists. And I have not seen a written waiver or anything indicating that either party waives that conflict.
Judge, we've spoken to her. She sent me an email, which is not a formal written waiver. The conflict exists in the client. I mean, she is fully aware of what we're doing. She has no problem with it. These cases do not intersect except in the personages, the instances don't. And she's not cooperating with the state, Judge. Where is she? She is not here. This is the second time she has not been here. But we'd ask for a dismissal. The state can not produce a witness.
Well, it's my understanding that they are going to produce the police officer
Correct,
in
Judge.
the
and I was
matter.
gonna give them a
So
call
I
and
think
their
that they
ETA.
can, right, I think that they can move forward with the police officer's testimony. And correct me if I'm wrong, Ms.
Change
Wall.
the fact that there is a conflict, Judge.
No, I understand that.
We first have to get over that hurdle before we can proceed.
And I guess the last time that you were here, regardless of whether there is or isn't a conflict, I asked that you present a written waiver.
Yes, Judge, and Attorney Fortis was the attorney of record at that point. I passed that information along to Attorney Fortis. I only recently did a substitution of counsel, in this case, making me the official attorney of record.
But you're still in the same firm?
Yes,
And I believe
Okay.
you appeared last time on this case.
I did.
Yes.
Okay,
So
so regardless, my request was that there be a written waiver,
Yes, Judge.
right? So, I mean, I think that without even that, then I'm reticent to move on with the matter.
Understood, Judge.
It was, have you all had a chance to speak?
no, Your Honor, we haven't.
Would you mind? Because,
Judge, I can stand
yeah.
on that.
right, and express to him what, okay. The only other matter we have on the calendar is Nichelle Stewart. In that case was null process. Ms. Stewart with us? I've signed that null process. Okay, I think that you all are the only case that's left. You all talk on this for a moment, okay? If you wouldn't mind, thank you. Court will be in recess until they return. You can have a seat, sir.
probated sentence for him to complete an anger management evaluation and any treatment deemed necessary, as well as restitution, subject to a restitution hearing. No further contact with Ms. Dennis, and then it will terminate upon the successful completion.
Okay, that's your understanding?
Yes, Your Honor.
Okay, so we'll wait for the paperwork.
Great, thanks.
Can I ask a question about
I think I'm okay with it. He is in
I'm
a,
in a 26-week program that I'm finishing now. Today is Thursday. It's a behavioral class with Dr. Parks. I have class today. I'm on my like 13 class. I have probably about like 14 to 15 more classes left. So I was just wondering, am I gonna have to read, because I actually have to pay for these classes. They're $31 a week.
What type of class is it?
I can actually show you on my iPhone. It's a because I have it in my calendar. It's today's Thursday. It's a men's class, ANA, it's ANA. It's basically like where people they get in arguments and they get in an altercation, then they have to take these classes on communication skills and just more about like how to basically walk away from a situation and use communication basically. But it's a class that I take every Thursday and that I have to pay for. So I was just wondering with this class, would I have to pay and take a whole nother class? That's what was just my question.
Judge, I believe it's through the Family Violence Prevention group.
So
Okay,
is it court ordered FVIP for another case?
No, I'm just taking it to help because I was recommended just to take the class, but I'm actually like have a relationship with Dr. Parks and I just take it just to help
So
with my
if you would send
communication
us the
skills.
documentation of that, counsel, that's something we will absolutely consider and let the court know.
Sure.
All right,
Thanks.
yes, ma'am.
so if you're, it's fine with the court, as long as it's fine with the solicitor's office. If y'all work it out together, then I'm happy to let that be.
All right, so what I'll have to do is just get my
Your attorney will get in touch with you.
Yeah.
okay, thank you.
Okay,
Let's get the documentation thing during class.
That's what I was gonna say. It sounds like it might be. Judge, so if he's currently enrolled in DVIP, if I put AMET on the disposition, on the plea sheet, so, I mean, will probation know to accept that in lieu of AMET? If he's provides the proof of that?
I would notate on the plea sheet to complete or provide proof of completion to probation and whatever the words are you're calling it,
right.
or letters.
Do we have, does he have the actual name of the program or?
Yes, I'm actually looking for the email because I have an email with documentation that I'm in the class already.
Okay, so
That I
look,
had to send to somebody else, so I'm just
Okay.
in my email.
all right, so look for that and we'll put that on the order.
And I apologize, Judge. That was all that I had on the calendar. Am I excused?
Yes,
Thank you, Judge.
I was actually gonna have Ms. Waldrop touch base with you, but since you're here, Ms.
Yeah,
Helen,
sure.
do we have any updates on Tuesday's calendar? You
I-
don't?
I do. I'm still in negotiations with the state.
Okay, that's fine.
I feel like we're close to a resolution that would also work with Mr. King.
Okay, all right, Joe, I just wanted to see where you all were. Okay, yes, you're excused.
Thank you,
Thank you, Ms.
Judge.
Helen. I'll see you on Tuesday then.
See you Tuesday.
Ms. Helen,
law firm, okay, no, that's right.
Is it wrong?
Mm,
One.
Oh, the one who was sitting right there when we were going over the.
That's different.
Oh, there's another one.
Oh, yeah.
Multiple pages.
Okay.
She was-
Good one. See you next week.
Look into the history from Ms. Robinson. Any workings? Oh, yeah, you've got to reach out to the like board and that they can be evaluated to see if they are or accepted.
so if you make,
Oh, right.
Yeah, but you're social.
but,
Given the murders, like breakthroughs and the DUI and stuff like that. NCMA.
They do have to make now, because you want to know whether they're gonna voluntarily participate.
That's when you just.
They found out, you can say, yeah, I'm sorry, I don't accept, you know, that you can reach out to the people, reach out to them, and just keep up with it to make sure it's moving.
They were merging. But they were really fast.
Would qualify for
Mhm.
if he has a 20 out of Fulton, and 2023 out of North Carolina,
Absolutely.
Okay.
2 or more, they qualify.
even in any jurisdiction.
You mean the conviction is injured? Yeah.
Okay. I'll text. Thank you.
But I found it.
one is about, imputed cost. You can. Let it be in the phone.
You know, QR code.
So y'all, if you can raise your right hand for me, do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you. You can place your hand down.
Yes, Judge. Mr. Ayala is pleading to the count of theft by taking. We've come to a resolution of a sentence of 12 months, balance probated. to get an anger management evaluation and complete any treatment deemed necessary. My understanding that he is currently potentially enrolled in DVIP. And so in lieu of that evaluation and treatment, if he provides successful completion of that to probation, then that would satisfy that condition. Restitution, that will be subject to a restitution hearing at a later date and no further contact with Ms. Deshauna Dennis.
Yeah, what is the restitution for?
It's for an iPhone, Judge.
Okay. Yes, counsel.
That's my understanding, Judge. We'd ask that you go along with the recommendation.
Okay. Mr. Ayala, it's my understanding that in case 21 CR 001301C, you wish to plead guilty to theft by taking. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol this afternoon?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes, Your Honor.
Has anyone forced or coerced you to plead guilty?
No, Your Honor.
I will accept the plea as negotiated. I don't know if you all discussed termination, but if there's no objection from the state, once you complete the terms of the probation, it'll terminate, okay? So the sooner you get it done, the sooner you won't be on probation, okay?
All right, so do I have to provide, because I just sent my lawyer a compliance form. Do I have to provide that I finished the class or that I'm still currently in the class?
You're gonna have to finish the class, so.
So I have to complete the last
you have-
13
right.
weeks, then get our probation.
Right, so you have to complete the class first, but once you complete the class and once you pay the restitution, then you won't be on probation. You'll be on probation until you complete that, okay?
All right.
Okay, so let's see, we'll give you where you need to report to probation today, and I ask.
I know, right there to up street.
Okay, and I'll ask that you report within the first 2 weeks or so, okay?
I'm about to go today because I don't even want to deal with it.
Okay, you probably don't want to go today because we won't have this in the system today, so give us a little while before you go so we can get it all transferred and then they'll know you're coming, okay?
All right. Thank you so
Okay,
much.
all right, good luck to you, sir.
All right. Good luck to you.
Thank you, Judge. And that concludes my business, if I may be
Yes,
excused.
we'll see you next time.
One moment, please. You don't need to. Have the phone. Oh, we just paid. So you want me to do like so compliance further notice?
Right, and then if I come up with the restitution, I can talk to him and just change the amount and they can do it, and don't have.
Email is where to send the class information once it's completed. So would it just be his probation officer? I'll just get it.
Okay,
Thank you.
Thank you.
all right, that concludes the 1:30 calendar. You all have a good rest of your day. Thank you.
Thank you, Your Honor.
Thank you, Ms. Carter. We appreciate it as always.
Judge, I'm waiting for the other people to go out. I have a question to ask you.
Okay,
Not the solicitors, but the other defendant that was.
okay,
So you need to bring them back in?
no. Yes, Ms. Carter.
On the other case that we had earlier today,
Yes,
the attorney was talking about a motion that had to do with the time and all of that. And okay, so they had to leave and go do the blood work. But then he was saying that it was possible that they could have used the 9,000 machine, what is it? Whatever that machine is instead.
yes,
But if he had gone to a place where that machine was, if he went to the first place and it wasn't available and gone to the next place, wouldn't that have been more time? Wouldn't that have negated his motion? Because he was claiming it took so much time. I just wondered, that's all.
Yes, ma'am, you should be an attorney.
Let's drop
Yes, that was scholarly book.
accepting application.
So do y'all want to answer a question?
Ms. Carter, this is James Birch. How you doing this afternoon?
Okay,
Good. So when an officer reads an implied consent warning after arresting someone for DUI, the officer gets to choose which of the 3 chemical tests to ask consent of the suspect, of the defendant. In this case, Trooper Buffington asked for a blood draw and did not ask for the breath test, which was the intoxilizer 9000 you're referring to, that Mr. Cleaver argued about. And he also did not ask for the urine test. And that was completely up to the officer's decision. The defense attorney was arguing that the breath test is a less invasive examination that could have gotten, science report of the blood alcohol concentration for the defendant. And there's a lot more arguments available for defense attorneys for breath tests with some new Supreme Court cases that have come out in the past few years. And so he was just trying to make that distinction on the record as an argument. But in this case, it's completely up to the officer as to which chemical test was performed. He was never saying that they could do both tests. He was just trying to make a point that, if he had done the breath test, that would have been a less invasive way to determine his blood alcohol concentration.
okay.
Does that make sense to you?
Yeah, it makes sense, but I just don't see I'm not a lawyer. I don't see the reason for the motion if all of that applies.
Well, hopefully Judge Morrow agrees with you.
The other thing that came out is that the
Okay,
trooper
well,
testified.
You know what? I'm happy to have y'all continue to discuss this, but I think I'm gonna leave
Okay.
and, I
The
will-
trooper testified that the place where they had the ability to test breath, the
Brent.
machine doesn't always
Brent.
work, and that's why
Right.
he didn't choose that.
But then I'm saying, okay, if he had gone there and it didn't work, then he would have had to go to another place. He's not
Correct.
sure if it would work there. So that still is more time. And he's
He was
saying
using-
the
he
whole
was
thing